Okay, shalom, 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 brothers and sisters. Once again, you're now under the sounds of the voice of your brother, Kahan Tazadak, coming to you through the spirit. First of all, giving all praises to the God of our forefathers, Abraham, Isaac, and Jacob. His proper name is Yahweh. For the record, this is not legal advice. I did not offer legal advice. If you need legal advice, seek yourself a competent counsel. And then please be advised, everything I'm about to give you is strictly for educational, informational, entertainment purposes only. It's not to be taken as legal advice. If you use any of this information, peace, shalom, Brother Donald Gill, and fall flat on your face is your own fault because you did not research the information yourself. And so as you see, I'm actually tuning in with an unannounced live stream, and this is how I do it. I'm going to give you a lot of vital information here that, a lot of information that I generally would actually just teach at the seminar. So, I appreciate everyone that can actually tune in. And I did send, out a massive email to 300 and some people. So, there's no reason that people that tune in regularly should not tune in right now. Now, unless you are on a just over broke, that many of you refer to as a job, and you're indeed just over broke because a $500, $400 emergency will put most of you in a condition that you can't handle, which is why I've been consistently telling you, become a secure party creditor, get my books. What are you waiting for? And so you could tell it's tax season because people that typically would eat at the McDonald's, the so-called black woman that typically eats at the McDonald's, oh, she's eating steak now. You know what I mean? She got a Gucci bag over her shoulder, despite the blackface now. Despite Gucci and blackface, she got a damn Gucci Louis bag on her shoulder. Tax season. Now, what you should be doing, all of you, if you're in your right state of mind, you would actually take that fiat from your taxes and become a secure party creditor under Tyler Dock. Because a couple months from now, you know what you're going to be doing? Crying the blues, talking about what you should have done and what you could have done. Do you have this book yet? The Infliction of Commerce. I have a packet that you could actually literally get all of my books, I believe, for $750 right now. And these books would typically cost you over $1,000, damn near $1,100 for all of them. Plus, I'm throwing in DVDs with it. Seminar DVDs, A4V DVD, authenticate your birth certificate. It's a giveaway. I'm almost trying to give you the stuff. So you need this book. You don't want to just become a secure party creditor. And if some of you will be honest, you became secure party creditors under other people, and you've been unable to get remedy. Why? Because they're not teaching you the way that I teach you. I teach you to get my books, study contract law so that you know it. Not forcefully believing some magical paperwork is going to make everything go away. And again, second edition, Charles Doc's book, Commercial Warfare. Tons of information in this book. Tons of remedies in this book. Writs, affidavits, how to become, a Hebrew national. It's in this book right here. And so most of the questions that a lot of you are asking me, it's already in my books. In that book. Those of you that's dealing with child support. The book that you really want is this. Another thick book here, man. Red pill right knowledge. Going to child support court. You don't know how to handle it? I won with the tactics that I have in this book. And believe it or not, some people actually, they have the book and they're asking me questions. And I say, brother, did you read the book? And he said, yeah. So, I mean, you couldn't have read it the 5 to 10 times that I suggest, because you would actually pick this stuff up and you'll remember reading it. Some of you donate for coaching. You'll donate $200 for an hour coaching from me, right? And so I was like, why don't you, get the book? Because coaching is limited and you're not going to retain everything that's said to you once, right? But if you have the book, you could actually read it again and again and again and again and go back to it. It's the purpose of the book. Another thing that's going to help you with child support and many other things is the corporation. This book. Tons of information in it. All of these books combined right now on my website for a few more days. You could get all of them plus a DVD of the seminar that contains over 10 hours of information, plus the Accepted for Value DVD, plus the Shock the Cop DVD, there's 250 alone, plus the Authenticate Your Birth Certificate DVD. All of that for only 750 is a giveaway. And plus this, the real Hebrew Israelites versus Edom and Khazariah. So this is all of my books, plus over 12 hours of DVDs where you can stop, pause, rewind, and learn at your own speed. And along with that, I told you to become a secure party creditor. With this information, you're asking me, what do you study? You study this. You use the same tactics that I use. Do I look like I'm poor, hungry, naked, out of doors? But you know what you can't overcome? You can't overcome the fear. So I'm going to say again, if you need guidance with a conditional acceptance letter, that's on my website. You contact me $8,000 and the conditional acceptance letter. But again, send the book. Plenty of letters like that in this book. In fact, in all of the books, this book it shows you how to get a loved one out of bondage. You understand? This book has a lot of valuable information in it. You need help becoming a secure party creditor? Go to the website now. Email me. Your pa has put the information in the room. Email me. Go to the website. Donate via Cash App if you don't like PayPal. But go to the website now, www.truedisciplesofchrist.org. If you need an affidavit of fact, we will help you one that is actually suitable to your needs. See, the problem that many of you are making, you're running to these Johnny-come-lately so-called sovereigns online, and they're filing documents for you, but you don't know how to handle commercial presentment. You don't know how to stand as a man or a woman. See, family, good record keeping is essential, and you're taught that in my books and on my DVDs. You simply created dedicated file folders, right, for each set of letters that you sent out. You keep copies of those letters. You mail them either registered or certified mail, and you have to request this when you go into the post office nowadays. You have to ask for that service. And you also copy the online receipts to verify that they've actually arrived. How many of you doing that for your secure party creditor packet? I can't tell you everything. Little things, you're going to have to be a thinker. If you're not a thinker, this is not going to work out for you, man. I don't give a college-type lecture teaching. I teach you through experience and by example, by error and failure. Do you understand? Do you understand? So you also, again, want to copy the online receipts to verify the arrivals that they received them. It's important to address all letters to, whatever organization you're sending it to in their private capacity. No fictional names. You understand what I'm saying? Does everyone understand what I mean by that? And if you don't, again, that goes back to you really not comprehending and understanding law. You understand what I'm saying? So does everyone understand what I mean by that about no fictional capacity? Does everyone get that? Do you understand? It's going to be in the private capacity, no fictional titles, because they are fully commercially liable if they're called into the open and dishonored. You understand what I'm saying? So, for example, they are not acting as a public legal personality with a limited liability. This is why you want to come at them on the private side. So besides that, you cannot deal with an artificial person, which is a corporation anyway, unless you consent to an act as an accommodation party, which is meaning that you're the name. You also need their physical address for the registered mail to go to if you're going to send it registered mail. Now, there are various conditions for a conditional acceptance letter for different situations. You understand? That's why I have so many in my different books here. There's different conditional acceptance letters throughout my books, depending on the situation. See, the problem that a lot of you make, you go to the damn internet, you download it, and it's not for your particular situation. You understand? Learn it the correct way. Learn it the way that Tazadak teaches you. This is not a damn sprint. Some of you want to be a damn Usain Bolt. No, you can't be a damn Usain Bolt, man. This is a slow process. It is a marathon. You understand? It is not to the swift. Do you understand? It is not a quick race. Yeah, that's right. Careful, you got to be patient. So dealing with bank credit cards, right? Mortgages and all kind of loans, any kind of loan. Because someone started out, what about student loan? Well, the last time I checked, that's on the public side, isn't it? Student loan, huh? Did not the government create the debt? Did not FDR in 1933 take away the gold? The government took away the gold and they promised to cover it. Dollar for dollar in House Joint Resolution 192, Public Law 7310, 48, Statute 48. Yes, Kane. So if you don't know how to do it, for educational purposes only, we draft letters. And Tazadak books also contain these letters that can actually be used to lawfully remove alleged bank debts arising from credit cards and mortgages or any alleged bank loan, car loan, student loan. You understand? Any alleged bank loan in the central bank debt money system. See, good brother, when you conditionally accept to pay upon verification of debt, you're exposed to fraud. Why? Because there is no lawful contract instrument. Do you understand? Commercial instruments such as credit card applications, loans, mortgages, are all alleged bilateral contracts which must be verified by wet ink signatures. I've been telling you this since 2009, man. Of both parties, not just one, of both parties, confirming a meeting of the minds. Consensuous ad addendum. So banks never sign, because if any bank representative signed on the behalf of the bank, they would actually be made liable for the fraud, thereby intact. Do you follow me? Moreover, in most cases, the fraudulent contract has been scrutinized, which means sold, relinquishing any alleged legal or lawful claim held by the bank, which nevertheless often receives insurance on the debt, having been fully paid while still sending out presentments. And so most of you, I mean, this is not meant for everyone, because many of you don't get this, despite how many times it's been explained to you. It's just not for some of you. Now, you asked me the same thing. So people, they contact me for foreclosure. Are you sure you can help me with the foreclosure? That the very moment that you have doubt, I already know I can't help you, man, because the doubt is going to block your remedy. You're getting in your own way. You're blocking your remedy with the doubt. The doubt will block your remedy. Do you understand? You got to come with a clear mind. So, foreclosure, right? You keep getting railroaded. To me, it's real simple to handle, right? There was no full disclosure. Banks do not really loan customers deposits, right? But instead, they issue money of account, credit in exchange for the alleged borrower's promise to pay. So in the debt money system, all money is only a promise to pay. A Federal Reserve note, right? A promissory note is a promise to pay. What do you think that means? So for all of you out there saying, this made up, that creditor, oh, okay, roger that. Copy. Then you could just keep it moving. There's no point if you stop it. See, they failed to provide full disclosure because they do not inform the borrower that the credit is actually created by your signature, the signature of the borrower making a promise to pay. I keep trying to tell people, they keep looking for something. It's really that simple. It incenses me how difficult it is to get in your head. It's really that simple. It's really that simple. It's really that simple, man. Do you understand? They failed to inform the borrower that the instrument of the alleged indebtedness is actually recorded as an asset and an action account payable. So in the hidden liability ledger, nor do they inform you when it is actually scrutinized, which means traded away, relinquished, any alleged claim they have over. And what am I giving you? I'm giving you the things for the contract to be valid. This alone, brother Jimmy Alicia, should be able to get you remedy in court. You fighting a foreclosure for 10 years, right? Come on, man, read between the lines. Contract is law, law is contract. Contracts are dynamic. Why is this so... I realize I'm a star seed, but I'm starting to feel like I'm a damn Martian. Why does this feel so damn simple for me and it seems so complex for everyone else? Why are people making it so damn complex? It's really simple. You know what it is? You think you're overthinking the process. Oh, it can't be that simple. No, I can't. Yeah, it's really that simple. The next thing, there was no valuable consideration on your alleged loan, on the car loan. You understand? Brother Donald, there was no alleged consideration. What do you mean by that? See, banks failed to provide valuable consideration because they bring nothing to the table. You understand? And so therefore, they have nothing to lose. See, each party to a contract must be both a promiser and a promisee. See, they must receive a benefit. And each suffer a determinant. So the consideration provided by both parties must be something of value brought to the contract table, and therefore a one-sided consideration is unequal and unlawful. But you don't speak this language. You know why you haven't learned to speak this language? Because you're not reading this. Like I told you, contracts are dynamic. You can make a move. So what with their alleged? Oh, we gave you such and such. Okay, well, prove it. What was the valuable consideration? Okay, there's not valuable consideration. They can argue all day. Creditors don't argue. We create harmony with the situation. Well, for the record, the law states if there's no valuable consideration, this contract is null and void. It's not a valid contract. Therefore, I had no obligation. You understand what I'm saying? That's the language that you should be speaking. It's unlawful if there's no valuable consideration. The terms and conditions are not lawful. Contract is law. Law is contract. Article 1, Section 10, Clause 1. No state shall pass any law impairing the obligation of contract. You have the right to contract, but guess what? You're contracting your rights away through ignorance, idiocy, ideology. Contract law requires full disclosure. Does not say. Brian Blum's book. I told you to get it. Why did I tell you to get that book? Not because I'm trying to promote Brian Blum's material, although I have over the years. His book's been selling like crazy. When you look for one of Tyler Doc's book, his come up right alongside of it. Why? Because that's the same book that they use in law school. That's the only reason I recommend that you get the book. Doesn't necessarily have to be his book, but in my opinion, it's one of the best. But it's written in a complex language. Difficult for a novice to understand that really don't understand law. Contract law requires full disclosure. Remember that, Brother Donald, if you decide to A for V that car. Contract law requires full disclosure, valuable consideration, and fixed terms. For example, variable interest is not valuable consideration, not variable interest. See, banks fail in this respect. You don't know how to handle the banks. That's how the doc does. How do you learn it? You learn it by getting we the people versus the corporation. First, you become a secure party creditor and become out of corporate ward status. Many of you, you're trying to do this in a damn corporate ward status. You understand? Talking about you a sovereign, but you're a citizen. Man, you can miss me with that. How the hell can you be a sovereign and a citizen? Is that not a damn oxymoron? So you're saying you are the authority and the slave? Because a sovereign is king, is the authority. A citizen is a subject. Subject to who? You're not subject to your own damn self. You're subject to a de facto that you call government. You're a ward of the state. And therefore, you're an enemy of the state because you're not one of their employees. The state has been actually federalized. It's a franchisee of the federal government. So you're federal babies. So conditional acceptance letters appear to be more effective for credit cards under $10,000 than for mortgages, right? So it is important to attach liability to one individual agent throughout the process. Who's going to be liable for this? You want to go after the company. No. Attach the liability to one individual. Who's corresponding with you? You find out Betty Ross's name and you go after Betty Ross for educational purposes only. Of course, I'm not telling you to go after Betsy Ross, right? And her war flag. See, it's important to attach the liability to one individual agent throughout the process while not being sidetracked or intimidated, like many of you are, by their letters or phone calls. Well, we received a letter. Yeah, we've seen this stuff. It looks like some sovereign stuff. This is frivolous filing. You could get in trouble. You're not supposed to be using this. And what do? You men, you start looking like those pretty pink panties that I see my wife, your pa, wear, and you start putting on damn pink panties. And then you start acting more like Goofy. Oh, yeah, I'm sorry. And then you start walking more like damn Donald Duck because they snatch your heart away with language. What is that? What do they do? It's just an offer. It's just an offer. It's not more than an offer, man. But you go into bitch mode. You understand? You start acting, maybe you've been smoking too much of that spliff, too much of that damn weed. They got insecticide and everything on the damn weed, and you bugged out of your damn mind. They're spraying the damn weed with roach spray and everything. You got to be bugged out of your damn mind anyway to be smoking that damn weed in this day and age. You don't know what the hell you are. You know what I mean? But, back to the subject matter at hand, man. So no matter what language they send you something, and you love to call Tazadaq when you get an offer that's actually spoken in a scary language. Oh, well, you might spend 2 years in jail and be susceptible to a $5,000 fine. They got you. If they could get you off it, let me ask you this, man. Think about this. I know you suffer from aphasia. Totally lost the ability to comprehend and utilize words because you've been taught in common parlance and colloquial speech, and these people are speaking in legalese, right? So when they say certain things, you just freeze up. Your mind just draws a blank. Your mind just draws a blank. But you got to be better than that. You got to gird up your loins like a man, as it says in the book of Job, 40th chapter, and Job 38, verse 3, gird up your loins like a man. And street talk, just grab your damn balls and stand up and be a damn man. Stop being weak, man. Stop. Because they're men just like you, but they realize they can intimidate you, and so that's what they're doing. So a lot of you could actually otherwise be successful, but because of fear, you won't do it because you can't overcome that fear. Do you understand? Do you understand? You got to stop being sidetracked by their threatening letters and their phone calls. That is just an offer. What are you supposed to do? There's only 4 doors that you could go through, brother Nicholas Carefoot. What is that? You could argue, which means you're going to lose. You get scared. Oh, why? That's the IRS. Okay. You get acquiescence, which means you're going to lose. That's dishonor. Or you could accept it. You could accept it and pay everything and, keep living just over broke. Or you can conditionally accept it. Because 99% of the times you're not going to like what they offer you. So a conditional acceptance, let me ask you this. How can you ever get in trouble? This is why I need you to open up your mind and think for conditional acceptance. Are you saying you're going to do a certain thing? No. What you're saying is, okay, I will accept your offer if you could actually prove that you loan me such. If you could prove you're doing that I did what you're alleging that I done. Okay, you're putting proof of claim because you're making a claim, and they don't make claims. Only a man can make a claim, right? But they're making a complaint, right? They're complaining. Attorneys complain. A man makes a claim, right? So they're alleging that I did this, I did that. Okay. Well, upon proof of claim, if you prove that, then I'm more than happy to pay this mortgage. I'm more than happy to go to jail because they make you an offer. When they make you an offer to go to a correctional facility, they're inviting you to go in to supposedly be corrected. What did most of you do? Well, Mr. Curefoot, we could have given you 15 years, but we're going to knock it down to 6 years. You acquiesce. You don't say anything. That is your opportunity to give a conditional acceptance, which is always a counteroffer. A counteroffer has the legal effect of rejecting the original offer and putting your offer in place of that. Now you become the plaintiff. But what do? You acquiesce, you go silent, and you lose. So what do you have coming to you besides some jail time? Do you understand? So you got to keep records of all communications, especially at the serving. So let's say you're serving a estoppel. Keep a record. See, when you can actually invoice them for each breach of your lawful binding agreement, then you got it. So I tell people again and again what to do at the seminars. Believe it or not, most of them should be on Ripley's because they asked me, tells what did I do? I was like, well, you got my books. You was at the seminar. You say, oh, they ignored my paperwork. Well, roger that. That's a good thing. Because when they ignore you, what are you supposed to do? You give them a notice of fault. They don't respond. I give them 10 days. I give them an opportunity to cure. Okay, roger that. Still not going to respond? Then I give them a notice of default. It's 30 days. But what more can you ask for? I reached out to them 3 times and they ignored me. Now I do the same thing that they do against you. This is exactly what they do to you. They send you a few notices. When you don't respond, they go to court and they get a default judgment against you every time. It works the same way in reverse, but you don't have the heart to do it. So you send 3 verifications of these notices. And if you want to, you can send a notice of irrevocable estoppel by acquiescence, constructing a lawful agreement. Do you understand? A notice of irrevocable estoppel by acquiescence because they didn't respond. You say they ignore my paperwork. Well, that's a good thing. But what do? Nothing. You don't do anything when they ignore. Constructing a lawful agreement. Do you understand? Do you understand? Well, I hope you do. I hope everyone is grabbing this. So now, there's been some brothers that's dealing with child support, right? Dealing with child support. Scared to death. Brother called me. Now, I'm hit you something. I don't know the guy's name. He gave me a fake name. You know what I mean? Yeah, if you could be real with anyone, you should be real with Taza Doc. Because, you know what I mean? I put my life on the line every day for you. But check this out, right? If you're dealing with child support, it's no different than these other things out here, right? It's a commercial court, right? It's all about offer and acceptance. Same thing. They're just going to play harder, right? Because it's a state-funded organization that actually, Salaki, excuse me, Sliha, to those of you that speak the modern Hebrew, it's a federal-funded organization that they use the state to go after you, and then they fund the state for every man that they prosecute. There's a few sisters. So, you know, sisters, those of you that had your children snatched away, that's very unusual. In most scenarios, you had to do something terribly wicked to lose your son or your daughter. But I'm going to show you how to deal with that in a few minutes. Try to drink one of these a day. Nevertheless, back to this. So now, dealing with some child support real quick. I'm going to give you a lot of case laws and you should be writing these down because I'm not going to leave this video up. So those of you that tuned into this live stream, it was a wise choice. But this video will be available for a donation. later on the website, but I'm not going to leave it up. So I hope you're taking good notes. So with that being said, let me give you some specific case laws for fathers, and then I'm going to show you how I stand in court and how to deal with these things and bring this thing to a close. So now, parental rights may not be terminated without a clear and convincing evidence. That's case law. Desantisky versus Kramer. 102 CT 1982. So remember, all of you that's actually having your rights deprived from you, remember that case law. Let me post that one in the room for you. Right there. There it is. You want to cite this in your child support chases and so on and so forth. Next one I'm going to hit you with. A child has an equal right to be raised by his father and must be awarded to the father if he's actually a better parent or the mother is not interested. There's Stanley versus Illinois, 405 U.S. 645, 1972. Next one I'm going to hit you with. If custodian mother has a boyfriend, listen up, man, because I try and tell this dude on the phone the other day that I coach, and he's running off, drop, jot, and tent. Just run, diarrhea of the damn mouth. I said, brother, look, hold on, man. You call me for coaching, didn't you? I mean, you call me because obviously your method wasn't working. He's like, yeah, you don't understand, man. Let me finish. I said, brother, you've been talking like 30 minutes straight. I haven't been able to say anything to you but shalom. So if you want to learn something during the course of this call, maybe you should let me respond right. But you George at intent, just running off at the mouth, not listening. You know what I mean? So I don't know about you out there, right? But I never actually learned anything from something that I already knew, right? The way that you learn is you learn from things that you don't know already. Nobody learns from something that you already know. So shh, be quiet, man, and learn. I mean, you're wasting your time. Nevertheless, remember this from fathers. If custodian mothers has a boyfriend living with her, the state can change custody to the father. That's case law. Jarrett versus Jarrett, 101 SCT. So that man that she may be having living with her, if you play your cards right, and you know what, and this dude that called me, he didn't even want custody of his son. You know what I mean? So, you know, I'm gonna hit you something, man. A lot of you men, you be off as hell because the woman's with someone else now. A lot of you men be acting effeminate, and you don't want custody of your son. You don't want to take care of your son or your daughter, but you don't want to live with his mom. Man, that's off as hell, man. That's off as hell. You understand? But that particular case law, I think I'll put that one in the room also. It's kind of big here, but I'll try and put it there so that you could actually use this. And you should actually write these down and put them in your affidavits of truth, affidavits of fact, whatever you want to call it. So the next one, custody could actually be awarded to the father of girls of tender years. Because a lot of people, nah, she should be with her mom. Well, not if the mom is no damn good. You know what I mean? If the mom's have a man and the man in the house, guess what, mom? You are a hoe. And she's probably better off with the father if he's going to raise her right. Custody can be awarded to the father of girls of 10 years if the mother commits perjury. That means lying under oath and is otherwise immoral. Like I was just saying. In other words, a hoe. They're using a nice language, immoral. That's Barber versus Barber, 322 NE, 2nd 910. Argument that joint custody constitutes a fundamental right. Beck versus Beck, 86, New Jersey, 480. Next one I'm going to hit you with. Mothers cannot take the child out of state. And this happens all the time. Again, I was on the phone talking to a good brother. Nah, man, she took him out of state and the judge allowed it. I say, well, the judge didn't allow it. You allowed it because you allowed the judge to get away with it. I mean, you can't primarily control what a judge does in the court at that particular time. But after that court is over, I can file an order to overturn the judge's decision. All I have to do is during the course of the court proceedings is object. For the record, I object. I object. If he's violating, his, authority as a judge, I'm going to object. So you got that, brothers? Mothers cannot take the child out of state if that prevents meaningful relationships between the filer and the child. This Wyatts versus Wyatts. 436 New York. So if she wants to move out of state and it's going to prevent you from seeing your son or your daughter, you can stop that. You can stop it. Next one. And there's a lot of case laws on that. There's so many on that. So many of them on that. Next one I'm going to hit you with. Ex parte conference. Hearing or orders denying parental rights or personal liabilities or unconstitutionals cannot be enforced, cannot be set aside in federal court, and can be the basis of suits for money damages. Did you get that, brothers? That's Raskin versus Howard, 633 F2D 844. Do you understand? Next one I'm going to hit you with. Judges' refusal to consider evidence of psychologist reports denies due process rights to meaningful hearings. That's Armstrong versus Mango, 380. Laws and court procedures are not that or fair on their faces, but administered with an evil eye and a heavy hand, discriminatorily or unconstitutional. So this is saying if a judge is being discriminatory. This is Yick Woe versus Hopkins, 118. Next one I'm going to hit you with. Federal courts can rule on federal claims, which means constitutional questions involved in state divorces cases and award money damages for federal torts, or in diversities of citizenship cases involving international inflictions of emotional distress by denial of parental rights and visitations. A lot of sisters, they love to play this game, right? They use the son or daughter as a weapon. The man has moved on. He's with a woman that's treating him better. The woman like his children. Guess what the evil sister does? She won't let that child go to his father. One brother I talked to, he said, well, every time it's time for me to have visitation rights, she says she got to take the kid to the doctor or something of that one. I said, well, she's violating because you can take it. You see what I'm saying? So this case law, you definitely want to use in that particular situation. Federal courts can rule on federal claims involved in state divorce cases and award money damages for federal torts, or in diversity of citizenship cases involving intentional infliction of emotional distress, because that's what she's doing to the man. How? By denial of parental rights, visitations, as long as the federal court is not asked to modify the custodian status. There's Lloyd versus Loafer. So, brothers, this is what you got to start using. You don't go in arguing. Arguing gets you nothing. You give a conditional acceptance. What is your conditional acceptance in this case? You're showing them the law. Show them the law. What can the judge do if you show him the law? He can't do a damn thing but obey the law. You understand? Next time I hit you with, because a judge, he loves to hit you with contempt, right? When they can't get you with something, they hit you with contempt of court, right? Watch this. Contempt of court is quasi-criminal. Merit of all constitutional protections. Expire versus Davis, 344 SW 2nd. Excessive fine and contempt. Cooper versus C 375 Nebraska 2D. Okay. Now, let's deal with some payments of the support tied to so-called visitation. Let me give you some of those case laws on that. It's too many to name here, so I'll post them in the room. Payments of support tied to visitation, right? So I hope you're writing this down because there's a lot of, and I'm not picking on sisters, but 90% of all child support cases are actually won by the female. And what's sad about that is females that actually don't have custody, more than 75% of those women don't pay child support. It's obvious what that goes to say. It's hypocritical. I'm going to give you another one. Although courts may acquire subject matter jurisdiction over children to modify custody through UCCJA, it must show independent personal jurisdiction. Remember that, brother, over out-of-state fathers. So if you're from a different state and they don't have jurisdiction, hey, you might want to use this case law before it can actually order him to pay child support. Do you understand? You know how many people get railroaded by this because they don't know the law? You live in a different state. She's filing for support in a different state. And so they don't have jurisdiction over you. But you don't know the law. I mean, the contract. You know why? Because you don't have this. And you don't have this. Specifically dealing with child support. So you lose. You don't know the law. So the case law on that is, let me give you that. Let me post a case law on that one right there. Superior Court. There's several cases on that. There's several cases on that. And the thing is, most of you don't get any of this because you're trusting in these lawyers and so on and so forth. And so you get railroaded. You're paying them to ask you a few questions. That's it. Let me post that. I forgot to post the other one here. Which one? It's that one. Let me post this other case that I just gave you. If you're actually out of state and some other state trying to hit you with child support, which is really not lawful if they don't have personal jurisdiction. Do you understand? They might have jurisdiction over the subject matter, but how do they have personic jurisdiction? Did you give it to them? This is why you men got to really start studying the law. I mean, the contract, which is law. So you really got to delve into this, brothers, and learn more. And sisters, if you're getting railroaded by some man, same thing go for you. Because, there's a lot of guys out here, they act, effeminate. They start acting like women, want to argue with the woman all the time and so on and so forth, want to play games with the children. Yeah, there's some men out here that behave like that. Because I know some sisters that actually contact me regarding men that actually have this kind of behavior. So there's a case law. You want to write those down, brothers. If you're in a different state, they try to hit you. This is the case law you want to cite. Attorney fees. Sums versus Sums 610. Attorney fees only if the court appointed in contempt for non-payment of child support. Ex pare McManus. Custody can be changed if visitation is denied. In other words, brother, if you're supposed, and I always tell brothers to keep a record. Keep a record of anything. And preferably, you don't want to call over the phone. You want to text. You want to send text messages which are admissible in court. And reason being, for educational purposes only, some states will not allow you to record phone calls and it be admissible in the court unless both parties agree, if it's a two-party state. Do you understand? So you want to actually, keep a record of those text messages. If she's denying you visitation, that could make her look as an unfit mom and she could lose custody over that. Unlawfully retaining non-custodian parent cannot argue change of custody at habeas corpus hearing. So Brother, if you've been unlawfully detained, you might want to use that one. Stay of execution by court of appeal protects its jurisdiction, not to protect the appellant's right. Justice delayed is justice denied. Brother told me that he had actually already filed several cases of child abuse against a woman, yet the court still awarded her custody once she brought up a child abuse case against him, which they found to be contempt of court because he didn't return the son when he was supposed to, because when she brought the son over, the son had a knot on his head, so he decided not to take him back, and so they said that he failed to return the child on time and therefore disobeyed a court order. Spouses can sue each other while still married for tort, and intentional and unintentional. Wow, I shouldn't. I guess I shouldn't put that one out there. Um, Judge's dismissal for no cause is reversible. That's the next thing I want to say to you. Now, you don't want to just use this one in child support, right? Sometimes you file a claim, a lawsuit, and so on and so forth, and the judge would dismiss it. I want you to use this case law that I'm posting in the room right now, because his dismissal is reversible. So this is why I'm telling you, you don't have any control of what the judge do while you're in court. But after you leave, you can file an order to overturn the judge's decision. Do you understand? Do you understand? Federal judges cannot set aside or overturn state courts to preserve constitutional rights. Rights to electronically record one's own conversation without beep note when life, liberty, or property is threatened, or to preserve scrutiny of home. So you have that right. Matter of fact, I believe I'll put that one in the room as well. Some of you may actually really need to use that particular case law. And yeah, again, I hope you're writing these down. And so one of the other things that most people don't know is actually how to stand in court. Like, they don't, when you go to court, you don't know how to enforce this because you don't know how to stand properly in court. So when you go in court, you screw it up. You give it a name. And by the way, there will be a premiere coming on my other channel, Deprogram Enlightener, tonight regarding more of this. So now what I would like to do is to actually show you how to stand in court, how to use interrogatories. Some of you don't know how to effectively use interrogatories. Some of you probably don't know what interrogatories are. But, hopefully after this, you will. And I'm not going to be much longer. I don't want to take this too long. So if you go to my channel, Deprogram Enlightener, I was actually doing a series of videos of showing folks how to actually stand in court. So interrogatories are actually written demands for information that actually force the other side to provide facts you need to win your lawsuit. And so, Brother Evans, I actually hope you're on the call so that you could actually pay attention, because you may actually need to use some of this with your lawsuit. So written demands, the other side must answer in writing and under oath or affirmation, right? So that's case winning power to those of you that don't realize it, if you know how to use it, that is. Now, I could actually teach you everything you need to know, in my books and in my DVDs, and by tuning into these live streams. Everything you need to know. Everything you need to know. Matter of fact, if you get these books, you will have everything that you need to know because your mind is going to start to think different. So the always question, right? Here's an interrogatory, right? I use every time. Identify all persons having firsthand knowledge of any fact relevant to the outcome of this particular case, and with respect to each person, state the facts known and whether you intend to call such person to trial. Now, you're sure to get an objection. You're sure to get an objection from the opposing party's lawyer. Do you understand? Unduly burdensome seeks to inquire into the attorney's client privilege nuisance. Well, that's okay. You'll then file a motion to compel the answer. And when you got to do the motion to move the court, right? And when you get to the hearing on your motion, you explain to the judge why the other side should be compelled to tell you the name, the address, and the phone number, facts known, so on and so forth. Then the judge will actually grant your motion because you will support it with a memorandum citing several control and appellate courts cases, making clear that to deny this information is an automatic reversal on appeal. Do you understand? The stupid question, right? It never fails to amaze me how some lawyers tack on interrogatories asking a person's answering to the identify himself or herself. That person's signature will be actually appended to the end of the response. And the notary will actually attest that same person swore to answer. But every state and federal court limits the number of interrogatories you're allowed to use. So it makes no sense to ask for information that you really don't need. Don't ask, do you swear to tell the truth? If they got an affidavit, they already done that. Use interrogatories only to get information that you will actually need to win. Now, some of you think it's about just going to court and objecting, right? Yeah, I was, ask someone, did he watch my video on objection? Yeah, I just object. Making courtroom objections is strategic, man. If you want to win in court, you must learn how to make an objection. You don't just object. You must learn how to make an objection, and the time to learn is before you go to court. I got people to contact me 24 hours before they go, 48 hours before they go, 72 hours before they go. If you don't, the other side will take advantage of you and will destroy you. And the judge will be powerless to stop it if you don't object. Any of you ever used to watch that show, Law and Order, and the other courtroom dramas, People's Court, Judge Judy? You mean? To hone your objection skills. You watch it with friends and so on and so forth. And you compete, to see who can make proper objections first. You or your friends, or the actors on the screen. Now, see, if you could actually state the legal grounds for your objections, then it makes sense. You can't just simply object. You literally have to have a reason to object. Do you understand? I told the one brother, yeah, just object. It's not that simple. So I'm going to give you a free comment, objections. And if you get my books, you'll learn how to use them with affordable step-by-step lawsuit help. Number one, ask and answer. Number two, if the attorney's badgering the witness. Number three, the best evidence rule. Number four, competence. Number five, counsel is testifying. The lawyer is making testifying statements. So now I'm going to have to put his ass on the stand. Number six, facts not in evidence. He's discussing something that's not allowed into the evidence. Where is this in the record? How can I How can you bring something to court that you didn't have in the proceedings? You understand? Or he's stating something, but he doesn't have any witness to back it up. That's known as hearsay evidence. It's only admissible if you don't object. I object. Hearsay. So you're given a reason why you object. I object outside of the pleadings. I object. Prejudice. I object. Qualifications. Qualify what you're stating. I object. Relevance. I object. Cause for speculation. Therefore, I object. Brothers, sisters, you'll be surprised how many damaging testimonies is actually admitted on the people's court. I sit and I laugh at these things. On Judge Judy, on Judge Joe Brown, so on and so forth. Damaging evidence that would never be admitted if the proper objections were actually made in time. So when and the same things happen to you, this is why you're losing your cases. So when it's your case, you can't afford to let the other side offer damaging testimonies. So practicing your objections with your courtroom dramas on TV, how's that working out for you? You know, see, where your opponent will play every dirty trick in the book to get the facts into the evidence that could destroy you and your case, facts that you must keep out with prompt and proper objections. So if you watch some of the courtroom dramas, they may help you with this. You understand? So you must object, beloved. You must object. So I'm going to give you one more thing. Trial rules versus pretrial discoveries. Then I'm going to bring this to a close. See, one of the dirty tricks that dirty lawyers play all of the time on you litigants who, don't know what I teach in my books and so on and so forth, is objecting to your pretrial discovery questions on the grounds that the information you're trying to dig up will be inadmissible at the trial. It doesn't matter. It does not matter. During the pretrial evidence, discovery phase of litigations, you read my books, if you read them in entirety, it'll come clear to you. You're actually entitled to any and all information that is actually reasonably calculated to lead to the discovery of admissible evidence. So what you seek doesn't have to be admissible at trial, as long as it is reasonably calculated to lead to the discovery of the admissible evidence. So you got to memorize those words, brothers and sisters. You must memorize those words. Get the official rule book for your jurisdiction. I tell people, get the rules, civil rules and procedures. Get the criminal rules and procedures. Read the general rules for pretrial discovery. You got to know what kind of rules this court is proceeding to. In the federal rules, it's Rule 26B1. So that the same or nearly identical language is actually included as part of the discovery rules that actually controls every state and the federal court. So when you're taking depositions, sending out subpoenas, serving interrogatories, requesting admissions, or requesting productions, you are actually entitled to discovery and information, not privilege, but you are actually entitled. That is reasonable, calculated to lead to the discovery of admissible evidence. Do you follow me? The facts you seek do not have to be admissible at trial. So as long as they will help you discover the facts that will be admissible. So when the lawyer on the other side tries to play the dirty trick in a dishonest effort to keep you from getting the truth, you quote the official rule and demand your discovery rights. It doesn't matter if the facts you seek during discovery will be admissible at trial. Facts do not have to be admissible during discovery. I can't overemphasize that. So as long as what you seek is reasonably calculated to lead to the discovery of admissible evidence. Then you have a right to get it, and the rules of the court guarantees that right. But brother, sister, you must know how to compel discovery using motions to compel motions to show cause and motions to contempt so that you could actually have people jail for not complying with the rules. Get this book, The Corporation. Get this book. Once your opponent faces a jail term for contempt, he won't be so slow to respond to your discovery request. All of it is explained in my books and DVDs. Do you understand? And so once you master this process, you'll start getting results. You'll start winning. So until you know how to force the court to put a stop to lawyers' dirty tricks so that you can actually discover the evidence you need to win, you don't have a chance if you're up against a dirty, tricky lawyer. Don't be a victim of courtroom corruption. Learn to win before the trial without a lawyer. The Tyler Doc's book, Corporation versus We the People, Red Pill Right Knowledge, Child Support Cases, Commercial Warfare, The Infliction of Commerce, Real Hebrew Israelites versus Edom and Gazaria. All of these you could actually get on the pack on my website right now. Plus, you will get 10 hours of the seminar DVD, over 10 hours of information, much more detailed information than I went over here. And you get how to authenticate your birth certificate DVD and how to properly conduct and accept it for value DVD. You get it all. So with that, brothers and sisters, I'm going to thank you for listening and tuning in. Again, tonight at 8 p.m. Eastern Standard Time, tune into the channel Deprogram Enlightener. I'm going to actually be going over some more lawful stuff that you could definitely use. So with that, I'm going to say shalom. I thank everybody for listening. You can get back to your just over broke. Those of you that's actually just over broke, peeking over the desk. Hey, I know it hurts. I know how it feels, man. I used to be in that same predicament. Someone telling you what to do. Someone telling you when you can take a break. Someone telling you when you can use your phone, man. Hey, man, I know how it is going to a job, being miserable as hell, a job that you don't like, but you got to do it because I got to be the breadwinner. Or so you think. That's what I used to think until I changed it. And so that's what you got to do. You got to change it. Do you understand? So with that, I'm going to say shalom. Shalom. Tyler Doc is out. Yahweh Bashem, Yahweh Shah, Barakatah. Thank you for watching. Like, share this.